like a GMC vehicle, United States Naval Academy, neck tie thing. If anybody's missing a set of keys, we've got them. I'll have them up by me up front, or if you know who they belong to, let me know. No takers. Looks like I'm going home in a new pickup, maybe. Our next speaker today is Marlis Big Eagle. She is the Victim Witness Coordinator for the U.S. Attorney's Office. Marlis has held a variety of roles in the United States Attorney's Office. She's been there since 1998. She works directly with victims of crime, and a lot of times we have a lot of presentations that talk about the laws and how we as lawyers need to maneuver our way through them and represent our clients, and we don't always get the other side of the story, especially if we're in prosecution or defense. Marlis is going to talk to us about the rights that federal victims of crimes have, and I think more importantly, how crime affects victims, and not just when the crime happens to them, but going through the process and afterwards. So if you'd all help me welcome Marlis Big Eagle.
Good afternoon, thank you for coming back. I wasn't nervous until I saw Megan's baby picture, and I thought maybe Randy would do that to me too. Thankfully, he didn't. So I am the Victim Witness Coordinator, as Megan said. I worked in the Rapid City office, most recently in the Pierre office, and now I'm in the Sioux Falls office. So I'll talk to you just briefly. I won't take long. I know sometimes victim issues makes people nervous. But the Crime Victims' Rights Act was passed as part of the Justice for All Act in 2004. And this gives victims, it really kind of balances the rights of the victim with the rights of the offender. And the federal government does all that's possible within the limits of available resources to make sure that victims of crime are afforded their rights. The list of rights, and there's 8 of them. The first, which I think is one of the most important, is the right to be reasonably protected from the accused. The next one is the right to reasonable, accurate, and timely notice of public court proceedings, which includes detention hearings, the release or escape of the accused. And how we make sure that that's enforced is if we have an indictment and we know that somebody's been arrested on, say, Tuesday morning, and they're going to have a hearing at 1 o'clock that same afternoon, and they may have a detention hearing, we usually let the victim know right away that they've been picked up. Sometimes they already know that. And then when the hearing is. And if they tell us that they would like to attend that hearing, we'll sometimes approach the court and tell them the victim really wants to be here. And this happened most recently in Pierre. There's a double murder case, and the family said, you know, we realize this is just another case for you guys, but this is really important to us as a family that we're there and that we represent our loved one, and this doesn't work for us. So we approached the court, and the court ended up rescheduling that hearing to accommodate the family. The right not to be excluded from any public court proceeding unless the court receives clear and convincing evidence that their testimony would be materially altered. And that came up in another case another homicide case where we were going to subpoena the parents of the victim, and they were going to testify about what happened before or the last time they saw their child, and then when they were notified of the death. And so their testimony wasn't going to be affected by listening to what happened at the scene of the crime or as part of the crime. And so they were able to sit in on the trial, hear the other testimony, find out what happened, and then give their testimony. And then the right to be reasonably heard at any public court proceedings involving a plea sentencing. We haven't had anybody come and talk at a change of plea hearing, but they do have the right to be heard at those hearings if they want to. We have had victims say that they disagree with the fact that we've entered into plea agreements with the defendants, but they haven't actually asked to be heard in public at one of the hearings. And then the reasonable right to confer with the attorney for the government in the case. And when this law was first passed and we were doing training on this issue, a lot of the attorneys would say, well, does that mean that we can have the victim witness coordinator talk with them? Does that count? And it actually says the right to confer with the attorney for the government, which would be the attorney for the government. And so we really have come full circle in that, and when we work with the attorneys in the case, they're really, really good about meeting with the victims. The right to full and timely restitution is provided in law, and of course we do the best that we can. We can't always force somebody to pay their restitution, but the victims do have this right. We do make those efforts, and we do everything we can, and our financial litigation unit and U.S. Attorney's Office is amazing. And then the right to proceedings free from unreasonable delay. You may actually see, if you're a defense attorney, a filing in court, quoting the CVRA and saying, the defendant has asked for, too many continuances, this isn't fair to the victim, we need to have this case resolved. They have the same right to being free from unreasonable delay. And then this is the last right, but I think it's one of the most important rights, and I think it's actually the foundation of the Crime Victims' Rights Act, and that's the right to be treated with fairness and with respect for the victim's dignity and privacy. And then this act really actually, like I mentioned before, balances the rights of the victim with that of the defendants. And the victims have been taking an unprecedented role in participating in the court process, so much more so than they have ever before. Like Megan mentioned, I started clear back in 1998, and we very rarely saw victims travel to hearings. They wanted us to call them and tell them what happened, but they rarely took part in the case. And as we meet with them and we talk to them about the indictment, what the charges are, and then make sure that they know what their rights are, I found more and more people are willing to come forward, speak up, and participate in the court process. So the Department of Justice just, has to make our best efforts to make sure that victims are afforded these rights. However, if somebody from the Department of Justice fails to provide one or more of these rights, victims can file a complaint in the district court where the case is being heard, and the Department of Justice can actually issue sanctions for Department of Justice employees for failing to afford victims their rights, and that may include termination. So that goes for every person who works in the department, not just me as the victim witness coordinator. So just briefly, to those of you that are going to be working with victims at one point, or maybe you are now, understand that there's a huge whole bunch of emotions that could be going on at one time as a result of the crime, and we call that the emotional roller coaster. There's a lot of fear. They may be fearful of the defendant, fearful of people finding out about what happened, fearful of what's going to happen next, fearful of the court process and having to testify. It's just a whole different number of things that could be going on at the same time. There's shame and guilt, shame that this happened to them and feeling guilty like maybe they did something themselves to make this happen to them. And then anger. They could be angry at the defendant, angry at law enforcement, angry at medical personnel, angry at us in the prosecutor's office, and just angry at the world and everybody. There's sometimes some numbness where we have like this flat affect, and it's frustrating for prosecutors because when we have people testify in court and we say, how did that make you feel? We want them to show some emotion. Sometimes they just cannot do it. Unfortunately, once they get it out and walk out of the courtroom, they sometimes have a breakdown and I can't get them consoled. And then there can be disbelief that this actually could have possibly happened to them. So just be aware that they notice everything. Sometimes they're hypersensitive to the way that you look at them, the way you talk to them. Your hand gestures, they may say something like, why are you looking at me that way? I feel like you're judging me. So a normal tone of voice can be calming and reassuring. And then sometimes normally self-reliant people just don't have any idea what to do, and they'll come right out and say, I just don't know what to do. Or I'll get a phone call from somebody and they'll say, I'm really having a hard time, I just don't know what to do, tell me what to do, how do I handle this? They may need those specific instructions from me, something as simple as, can you please sit down? And then referrals, if you could really get to know your community and what resources are available out there in the area that you work. Randy showed you a slide earlier where all of the attorneys in our offices are assigned to a specific area. Getting to know the resources that are available to help victims is so important, because a lot of times those of us that work in Indian country find out that victims of crime don't necessarily want to use a licensed professional counselor for mental health. They'd rather use a spiritual leader or medicine man. And so if you have an idea of either who the spiritual leaders are in that community and where they live, that you can make those referrals to them and have them hook up with them to try to help some of their healing from their victimization, that would be really, really good for them, because healing ceremonies sometimes are more effective than anything else. And then understand that as time passes, sometimes those feelings lessen, and they may want to just work this out and not proceed with the criminal part of it. The justice sometimes goes really slow, and it takes sometimes a year before a case resolves. In that time, there's a lot of things going on. The family may have healed itself, or they may have forgiven the defendant, but sometimes they don't always want the case to end. They may say, I've forgiven this person, I worked it out, but I still want him or her to be held accountable for this crime. I had 2 cases just recently where they were both domestic violence cases, and in one case the victim came to court and said, I don't want to press charges on this person. I love him and I know that he was a victim before this happened. That's why he's doing the things he's doing and behaving the way he is. So I don't want to proceed with this case at all. He needs help. I want him to get that help. The other person said he's never been held accountable for his behavior. His family has blamed me from the very beginning. They blame law enforcement for this. He's never been held accountable. He's never apologized for anything that he's done. He needs to accept responsibility for his behavior. And there's no way I'm going to let this case go. You have to proceed with the charges on this. So those of you that are working with defense attorneys, and prosecutors, really think outside the box on this, because violent crime is a community issue, and we've talked about that. Our office has done some pretty progressive things to try to address that in a proactive approach rather than just prosecuting. So if there's some things that you can think of as far as a creative plea agreement or some alternatives to agreements, mention that or bring that forward and bring it to us. I know that our office would be happy to review that and consider that. There's been a lot of times that defendants have offered to speak to the community or speak to kids about their behavior, the things that they've done. I would encourage you to include that as part of the plea agreement, or if that's something that they want to do, then maybe we can include that. I think it might help with recidivism if the defendants are doing something more productive to atone for their crime rather than just sitting in jail. And lastly, I wanted to just briefly talk to you about some of the things that we did in our office. When Brendan was on board, he reached out to a lot of the youth groups, and we had 4 different listening sessions. One in Watertown, Mulbridge, Lorville, and Martin, and they bussed in schools from the tribal schools to these different sites. We broke the kids up into groups and talked about domestic violence, bullying, gangs, alcohol, drugs, and suicide. And there was an informal survey in one of the days that I went, and I listened to some of the kids and I made some notes about it. And I really think this is important for all of us here to hear about and to listen to, because that is the next group of either tribal leaders or defendants. They were asked if you've ever felt like you lived in a haunted house, and if so, why? And the answer was, I feel like I live in a haunted house when I watch my mom get beat up by my dad. I feel like I live in a haunted house when I watch my brothers and sisters get beat up. It feels like a haunted house when there's more than one stranger in my house. And I feel like I'm living in a haunted house when I'm living with this shame, guilt, and all the alcohol. And then one kid actually said, there's just no way you can sleep these feelings away because they come back anyway. And then when asked how many of you want to go to college, 100% of them said they wanted to go to college. 90% of the kids in the classroom said they wake up every day tired and hungry. 6 of them, and this is probably a group of maybe 50 students, admitted smoking marijuana that week, and 2 of them said they knew that of 11 and 12-year-olds using methamphetamine. When asked how would life be good, 100% said life would be good if there were no drugs, no drug users, no alcohol, and no men who hit women. So here's some resources that I just put together that maybe you can reach out to in your area. There's a lot of things, a lot of other resources available out there, but here's some of the places that I've worked with and people I've worked with that have been able to help work with some of the victims of violent crime, domestic violence. And there's we have a victim witness coordinator in every one of our offices in Rapid City, Pierre, and Sioux Falls, and there's the phone numbers if you want to reach out to any of them and ask for some additional information about either the victim witness program, about victims' rights, or what resources are available maybe in the areas that you guys are working. So I had about 10 minutes, I think, for that, and if you have any questions, I'll be around as well. Thank you.
Our next speakers are going to be Sarah Collins and Troy Morley. I'll have them come up here while I get the next presentation. As I indicated, our 2 presenters are Troy Morley and Sarah Collins. Troy is the tribal liaison to the District of South Dakota. He works with all of the tribal leaders and tribal courts and tribal prosecutors on various issues in Indian country. And Sarah Collins is a senior litigation counsel for the District of South Dakota, working again in Indian country, dealing with a variety of issues. Troy handles cases off of Standing Rock. on the South Dakota side, but has a great working relationship with the North Dakota side as well. And Sarah handles the majority of cases off of Pine Ridge. And then as Randy talked about, she's been involved in a lot of those Sturgis motorcycle to catch a predator type scenarios. So we're really pleased to have Troy and Sarah here. They're going to go into a little bit more detail about the ability of tribes to prosecute non-members and what System is up to. So if you'll help me welcome Troy and Sarah.
Good afternoon, everyone. This is really an evolving area of law, and so Troy and I are going to do our best to talk about it. If you have questions, we're happy to try to answer them. If we don't have an answer for you today, we can certainly try and find it. But as we try to navigate through this, we'll try to help you navigate through it as well. This again, Randy kind of stole our thunder, but as our boss, I guess he gets to do that. This is the photo of President Obama signing VAWA 2013. Today we're going to be talking about VAWA 2013 as well as TLOA, and what we really like to highlight first of all is the fact that it was not a single brand new law. It wasn't one statute that was written and put into law. It amended several different areas of law. The Indian Civil Rights Act, the Full Faith and Credit Statute, which is regarding protection orders, which is of vital importance. Anybody who spent a lot of time practicing law in Indian country knows it was a constant frustration before. When a person would have a valid tribal protection order, someone would walk through that protection order and no other courts found that protection order to be legitimate. And so this was a big modification that I think and I hope will continue to make a difference. And then there's the federal assault statute, where there was a couple of different sections added. Probably the most meaningful ones that we see the most often are subsection 7, which is used to just be the assault causing substantial bodily injury to a person under the age of 16, and now it added the domestic violence terms, the spouse, intimate partner, and dating partner. So that was another big step. The other one is the strangulation and suffocation statute, which deals only with the domestic violence victim. And so those were just a few examples of how the federal assault statute was modified by VAWA. But we need to start with TLOA, because this was actually what kind of kicked everything off. That obviously came 3 years earlier and amended ICRA. And as Randy talked about previously, it restored the tribe's felony sentencing authority, but only if certain caveats were met, only if certain standards were met, and afforded certain rights according to the defendant. Meaning that the tribe has to have these things in place prior to being able to get that felony prosecution ability. Number one, there has to be the effective assistance of counsel, at least that which would be guaranteed by the United States Constitution. And the person who is representing the defendant has to have a license to practice law in any jurisdiction in the United States to keep those professional licensing standards up and ensure that the person is effectively represented by legal counsel. The next affects the judge that can preside over the criminal proceeding. Number one, they have to be legally trained as a criminal in the criminal law. They have to have an understanding about the proceedings and the law, and they too have to be a licensed attorney. Number four, that the tribe actually has to have their law be made public. That means all of the different law violations, but it also includes any rules of evidence and rules of criminal procedure. Anything that governs the practice of the attorneys and judges, all of that has to be made public prior to anybody being actually charged under the law, the tribal laws, which are allowed by TLOA. And then number five, the trial has to be recorded in some fashion, either by audio or some other recording mechanism.
All right, in addition to that, there was also amendments to the Indian Civil Rights Act when we're talking about the new special domestic violence provisions. And what it did was help define the nature of that criminal jurisdiction. And if you look at the amendments they made, one of the first things they did is they recognized that the tribes had this inherent authority to begin with. And that's important for a few factors. One, this is a recognition of tribal authority. This is not a delegation of federal authority. This is a similar matter where you will see people prosecuted by the state and the federal government. Again, a prosecution in tribal court will not hamper our ability to bring federal charges if it is determined that they are warranted. And what it did is it recognized and affirmed their ability to exercise this special domestic violence jurisdiction over all persons. So now you no longer have to be a member of a federally recognized tribe to be prosecuted in tribal court, but only under these domestic violence provisions. This isn't a recognition of general criminal authority, but only in this area. So when can the tribe exercise this jurisdiction? It's for criminal conduct that falls into basically two categories. One, those are going to be domestic violence and dating violence that occurs in Indian country, as long as the tribe has afforded certain safeguards to the people that they will be prosecuting under this enhanced jurisdiction, and as well as the violations of protection orders that occur in Indian country of the participating tribes.
We're swapping back and forth. You gotta love the alphabet soup of the federal government, right? Is that the longest acronym ever? SDVCJ. It still doesn't roll off my tongue after this amount of time. The definition of domestic violence under the SDVCJ, whatever that long acronym is, it's very important. It includes all of the things that we think, under general state law would classify as domestic violence, meaning that it's somebody that you've been involved in an intimate relationship with, somebody you've been married to, somebody you cohabitated with, somebody you've shared children with. Those general situations in which we consider domestic violence. And the important part is that it's either a current or a former. So this could be an ex-boyfriend or an ex-girlfriend or an ex-wife, and these would still cover. And this is the definition that is under the 25 U.S.C. 1304A2. This next slide is of an example which all of the language in general matches the prior slide, which is the 1304A2. This is Sisseton's definition of domestic violence. But what the domestic violence under this statute holds, it omits the a family or household member that Sisseton's and many of the other tribal codes, that's my understanding, also include. So it's truly the domestic violence type definition where it's somebody that you've been in an intimate relationship with, you've been married to, you share children with, but not a family member or household member.
That last distinction is important for one other reason. When you look at the habitual domestic violence under 117, for the predicate offenses under domestic violence, in order to rise to a habitual level, those situations where you may have a domestic violence conviction and it may be against a mother, a brother, or a sister, but not a child or an intimate partner or spouse, those don't qualify as predicate offenses under the habitual DV law. So in some way they're being consistent there in federal law by keeping the same ones going, and I think I went in the wrong direction there. Okay. So what rights must be afforded to the defendant for a special domestic violence criminal jurisdiction case in tribal court? What they've done is they've extended basically the Bill of Rights. They've made it mandatory to the tribal courts now. Before, under the Indian Civil Rights Act, it mirrored the Bill of Rights, but it wasn't a full imposition of the Bill of Rights on tribal courts when they had jurisdiction over Native Americans and members of federally recognized tribes. So now any imprisonment, any term of imprisonment, then all of the rights we discussed already under TLOA, they must be afforded to the people who are being prosecuted under this special domestic violence. One thing to note, under VAWA and TLOA, while it's aspirational that they go together, it is not mandatory that both provisions be adopted. So what that means in Sisseton right now, they have adopted VAWA and they can start exercising jurisdiction over non-Indians. However, they don't have the 3-year sentencing authority over their own members. They have not afforded the rights that they're required to here to their own members, but the thing holding them back, the only thing stopping them from adopting TLOA at this point is their jail facility. To exercise felony jurisdiction, they need to upgrade their facilities. They're looking at contracting those facilities out right now. And it should be noted the people that they prosecute under this special domestic violence criminal jurisdiction will be housed in local county jails to make sure that they are up to the codes that's required of this. Now, there's going to be some exceptions. There's some exceptions to this. Now, this isn't going to apply, and the most classic example we can think of right now is on Siskin, they have 2 tribal casinos. So if a couple comes down from Fargo, neither one of them have any ties to the reservation, neither one of them are Native Americans, and they get into a fight in the casino, the tribe does not have jurisdiction over that. That would remain a state offense. So we need to make sure they have sufficient ties. This is what they have come up with at this point for what sufficient ties are. Either they, one or both of them, reside in Indian country, or perhaps it is an individual employed at that casino and he's dating someone at that casino, and then it happens that could be found as sufficient ties. And then if they're a spouse, intimate partner, or dating partner of a member, and that person is residing in Indian country and they travel to Indian country to commit this assault,